Hi, good afternoon, everyone. Welcome to our community conference calls at the law offices of Rajiv S. Khanna PC, immigration.com. We do these calls every other Thursday. We'll answer the questions that have been posted to our forums, forums.immigration.com, where some of the questions I have marked as frequently asked questions. I will answer those first, invite your follow-up questions, no new questions at this time. And then I'll answer the rest of the written questions, posted questions. And in the end, if time permits, we'll answer new questions. Today is September 29th, 2022, and the calls are subject to the disclaimers that you heard when you logged in. Let me go on to the first frequently asked question today. So the question that I was asked today was, my STEM extension is expiring. What are the options to stay in the United States? Is day one curricular practical training safe and legal? So, is day one curricular practical training safe and legal? Well, it is legal, and so far it has been safe. There was a point in between where USCIS was questioning a lot of things about curricular practical training because they don't want to see the CPT being abused. You know that the rule for day one CPT requires that when you are joining a graduate program, otherwise you can't get day one CPT. The curricular practical training is an integral part of your degree. You can't finish the degree without the practical training. And 3, the employer signs a cooperative agreement with the university. So all these are mentioned in my blog on immigration.com. The only additional suggestion I have is that if you are going to do curricular practical training, make it as an adjunct to your profession. So for instance, if you have a degree in, let's say, information systems, and you have a lot of interest in data analytics. So the next degree that you are going for CPT, make it that it is a degree that has to do with analytics or some specialization, for example, automation within your information systems major, whatever you're interested in. Is it safe? I think it is safe. And what is the worst case scenario? If the government says, well, we think you are just making this degree an excuse, so we will not give you an H1 within the United States. You have to go outside USA to get a visa stamping. That's not the end of the world. Although increasingly for the last few months, we have seen the government not create a problem with curricular practical training, change of status cases. I forgot to check today. Let me make sure you guys can hear me 1 second.
The conference is now in conversation mode.
Can you all hear me, guys? Can you all hear me?
Yes, we can.
Okay, good.
Yeah, we can.
Okay, excellent. Thank you.
The conference is now in presentation mode.
Does anyone have a follow-up question on curricular practical training? If you do, press *5 on your phone. No new questions, please. Okay? *5. There is one question from area code 607. Area code 607.
Hey, Rajiv, can you hear me?
New York, huh? Go ahead. I can hear you, yes.
Hey, Rajiv. Actually, yeah, I'm in Dallas right now, but that was my master's code.
Okay.
So, yeah, I was the one who posted that question, and I wanted to know, as you mentioned, it is already safe and we can practice that, so that is fine. But assuming my H1 doesn't get picked in the upcoming March, right? And I go for that thing, I start my master's, the day one CPT thing, and how much can I go for? Is it for 1 year or can I extend that up to 2 years as well, depending on the coursework? I have seen cases where people, they extend their...
Exactly. You answered your own question. So it depends upon your coursework. If your coursework allows, I know PhDs who have had curricular practical training for multiple years. So it depends upon your coursework. You can check with your DSO. Okay.
Understood. And can I travel internationally? Is on that thing?
Yeah, no, that's a little bit
Once I
hinky.
start my D1 CPT,
I am a little concerned about those cases, although again, I haven't had too many, not too many, I haven't had any reports of people not being able to be readmitted while they were on curricular practical training. Because remember, the government at the airport, Customs and Border Protection, is not looking at your CPT. They are looking at your I-20 endos for travel, and at the most, they can ask for evidence that you have been taking classes full time, which is what you do when you're on student visa. So the answer to that question is I have not heard any adverse reports on travel. Okay.
Understood. That makes sense. And if I do, I will have to get it stamped, right? My visa. If I go travel.
Yeah, if you absolutely, if you don't have a visa stamp, F1 visa stamp,
Right.
you will have to get it stamped, and that makes your situation rather.
Understood.
That's a difficult thing. So
Exactly.
I wouldn't want to do that if I were
Right.
you. Okay.
Understood. Thanks, Rajiv. That
You're
clears
welcome.
all my doubts.
You're welcome. Good luck. Okay, let's go on to. I think we are done with this question. Let's go on to the next frequently asked question. So parents who are green card holders applied for re-entry permit, left USA. Do they need to come back to the US? It's because they left, I guess, about when? My parents are green card holders applied for the I-131 in September. So in September 2022, it will be 1 year since they left. Okay, now this is a really weird situation. There is no particular law that I am aware of that says you have to come back before that 1 year is over. The way I look at it is this. Under the law, if you are outside USA without a re-entry permit already approved, your green card can be taken away after 1 year. It's automatically gone. But if the I-131 gets approved, that protects you. So the situation is, if the I-131 eventually does not get approved, they could have a difficult time convincing the consulate to let them return because their green card would be lost. So as a practical matter, what should they do? Well, this is already, I guess it's already too late, right? Because they left USA in November. Okay. So if they can come back before November, I think that would be a good idea, just to be safe, because you never know how it's going to play out, right? What guarantee do we have that the re-entry permit will be approved? Although it's very rare for re-entry permits to be denied, at least the first 2 years. Okay. So *5 if you have a follow-up question on this. So my recommendation would be return if you can, although the I-131 I think will be ultimately approved. Most of them are. No follow-up questions? Okay, let's go on to. Here's another one that gets asked a lot. What are my options if my employment-based I-485 is denied? A lot depends upon the reason for denial. Okay. So what if I have an H-1B approved and that's good for another 5-6 months? Even if the I-485 is denied, can I finish my H-1B term? Oh yes, absolutely. Absolutely. You can finish your H-1B term. After retrogression, can I transfer H-1B? Well, like I said, a lot depends upon the reason for the denial of the I-485. If the denial is for something technical, some fees were missing or the case was filed too early, your priority date is still valid. And in all probability, your right to extend your H-1B through any employer is still valid. And you can always refile an I-485 with the same I-140 if that is still valid and you are working with that employer or have an offer with that employer, or even start an entirely new green card, carry the priority date forward. So there are too many permutation combinations for us to give you a definitive answer. Each case is different, but there are options, and definitely an existing H-1B term should not be disturbed. Now, I'll give you one caution there. If you have an H-1B approval, but you started using your employment authorization, then you will have to leave USA, come back on H1 visa. If you have already a visa stamped, you can just go to the border, come back, and you are back on H1B. If your 485 is denied, just go to the border, come back in. And if it's not stamped, then you'll have to get it stamped to come back in. But that's definitely an option. Okay? Press *5. Press *5 if you have a follow-up question on this issue. One of your question was, after retrogression, can I transfer H1B? I don't see why not. Because the rules of the H1B are proceeding somewhat independently of your 485. I say somewhat because there are some reasons for which if 485 is denied and you don't already have an H1B, it may not cover those situations. For example, H1B is denied on the merits. The I-140 was revoked, for example, or something like that. Then you will not be able to extend your H1B. Whatever you already have, you should be able to use. Okay, let's go on to the next frequently asked question. Folks, if you have posted a question about DV lottery, I don't know anything about DV lottery. So you please might make a note of that. So here is a question. How can I maintain my H1B while working outside the USA? Couple of things you need to remember. First of all, H1B gives you the option to work in the United States, but not the obligation. Let's say, in this case, for example, I'm a Canadian permanent resident and I have an H1B, but I moved to Canada and I either work or not work from there. If I continue to work on the H1B job, is my H1B status valid? Well, that's a little bit of a misleading question because you can continue to work and you don't really need an H1B. But is your H1B still valid? To the extent that when you come into the United States, let's say you come for 10 days to work in USA, you should work strictly according to the H1B terms. That H1B is still valid. And not only that, all the time that you have spent outside the USA can be recaptured. So technically that H1B can be pretty much extended indefinitely. There is in law something called intermittent H1Bs, which specifically speaks to this situation. So to answer basic questions, can I maintain my H1B while I work from outside? Sure. But maintaining an H1B simply means that your H1B is not destroyed just because you're not working here all the time. Okay? And also remember that you can recapture the time outside, whatever time you spend outside. So this H1B could pretty much go on indefinitely if you want. *5 if you have a follow-up questions. Okay. By the way, I also have written an article on this. If you Google my name, Rajiv S. Khanna, The Economic Times, I wrote an article on this and I thought that some of the Department of Labor's requirements were crazy and they would probably lose in court. So just take a look at that article also. I don't see, this is another interesting frequently asked question. Now, folks, this you might want to pay attention to. Okay. So the question is, how many times in my life can I get STEM OPT extension? And the answer is, you can get STEM OPT extension twice in one academic life cycle. So if you study in the United States, you can get STEM OPT extension twice. How does that work? The only requirement is the next degree for which you want to get OPT again, STEM OPT extension, should be of one higher or higher category. Example, if you got an OPT, STEM OPT for bachelors, next STEM OPT would be for masters or for PhD. I also want to add one more point here. Sometimes this situation presents itself and there is a rule covering that. Let's say that I did a STEM degree. After STEM degree, I did a non-STEM degree. But when I did the STEM degree, I didn't get the OPT extension. I just went down to non-STEM degree. After I finish my non-STEM degree, can I still get STEM OPT extension? The answer is yes. How does that work? So the law says if you have finished a STEM degree in the last 10 years, counting back from the date you apply for STEM again. You have not used that STEM degree to get STEM extension. Then you went into a non-STEM degree. If you apply for OPT in the non-STEM degree, which is your most recent degree, you can actually, after that, just like you would normally, you can recapture your STEM OPT from the old degree. I hope this makes sense. So in other words, even if you did a STEM degree and never used the STEM OPT extension, you should be able to reuse it if you meet those conditions. I hope that helps. *5. If you have a follow-up question, press *5. I think those are all the frequently asked questions. So here is another, there is a follow-up question from area code 312, which is Illinois. Illinois, go ahead, I can hear you.
Hello.
Yes, ma'am.
Hello.
Yes.
Thanks for taking my question. So is this scenario only with STEM and non-STEM? Let's say if we have a master's and not used our STEM and then did a PhD, so will we get 2 STEM extensions?
Oh yes. So I talked about 2 different case scenarios, right? One case scenario is, the first one that I talked about was, in your life, you can get 2 STEM extensions. The only requirement is that the second degree should be higher. So if you got a STEM extension during your master's, you can also get a STEM extension after your PhD.
Okay, so in my situation, I did a master's and then joined immediately for a PhD. Now I'll have 1 year of OPT with 2 years of STEM extension. So since I did not use my master's OPT, can I count it to this one or no?
No, I do not believe you can. Because you already are eligible to receive your STEM OPT extension, and you can't get 5 years. You can get 2 more years. You can get 3 years. Okay.
Thank you.
You're welcome. Good luck. Okay. Let's see. So this is another interesting and very weird situation. I don't have the exact answer, but I do know what happened in a similar case a while back. So a person has a green card pending. They leave the United States on advance parole. While they're outside the United States, their green card gets approved. But they've already been outside the USA for more than 180 days. Are they going to have trouble with their green card? And what if they don't return for another year after this? Well, I'll give you a case that I ran into, and I thought that was a very poorly briefed case because the government didn't seem to have a case to kind of maintain. Similar situation, the guy left and he was out for 1 year. The government approved the green card, but when he wanted to come back, they said, no, your green card is now gone because you've been outside for 1 year. And my first question was, well, his green card has been approved only 120 days ago. He's been gone 1 year, but when he was gone, he was on advance parole, and he still has an advance parole. So it's a little bit of a buggy, ambiguous situation. Your friend should return as quickly as they can, at least come for a few days and then go back again. That way, there is not a 1 year gap. That's what I would recommend. That's the practical solution. If you want an entire theoretical exploration of what your friend's rights and liabilities are, you may have to hire a lawyer to do some in-depth research. I don't think this is an answer anybody will be able to give you offhand. Okay? And there's no way to apply for a reentry permit if you're outside the United States. So the clock could start ticking when he left. That's what the government says. I think they are wrong. I think it should start ticking when the green card is approved. But nevertheless, that's where we are. *5, if you have a follow-up question on this, press star 5. Okay. I'm going to lock the conference just to, wait a minute, I usually lock after half hour. So we've been going, we started at 12, right? I always forget what our start times are. Yeah, I think I'll lock the conference another 11 minutes, 12 minutes. Okay, next question is, this is question number 4. Switching to H-1B status from F-1 STEM OPT, effect on H-1B if switching employers before stamping. Oh, I see. So you have a STEM OPT which is good till next year June, or next to next year June. Okay, H-1B got approved, and I guess you have consular notification option. So it won't start until you get your H-1B stamping. What happens to my H-1B status if I switch employers before stamping? This is a very interesting situation. There was a time USCIS was insisting we don't consider the H-1B process to be completed until you get a change of status or you get a visa stamp. Although we have done many transfers without these two conditions being fulfilled. So my guess is you could transfer. Can I guarantee it? No, because the government has said time and time again that we don't think your H-1B process is completed until you get change of status or visa stamping. I don't think they are right, and I don't think they are implementing that, but there you have it. What do you do? What do you do if you want to be safe? Well, you have two options. You can actually apply for a change of status within the United States. It's like refiling the case, but it's not subject to the quota. Do it premium processing. Now you have a completed H-1B. You can transfer without any problem, especially if you do it after October 1st. Okay, that's the practical solution. Now, if for some reason government says, oh, no, this transfer cannot be approved, and let's say you don't take the method I suggested and you just try to directly apply for a transfer, and the government says, well, you never got a change of status, we can't approve this, they cannot take away your STEM OPT. You are still on STEM OPT. You're still working. As long as your DSO has not invalidated your service number, you can continue working on your OPT. I don't see any problem with that. And they should not have invalidated your service number because you applied for consular processing. If you had applied for change of status, that's one of the things they would do. They would invalidate your service. But here they should not have. So it appears to me one of the options, and a good option you have, is this. Simply apply for an H-1B transfer. If you get it, great. If not, you've got your OPT. You can continue working on your OPT. Star 5, if you have a follow-up question on this, press star 5. Okay. Next one. Okay, we covered these frequently asked questions. Can I use my EAD-AP if I have withdrawn my EB-3, which was the underlying petition for 485? So this is a case for a physical therapist who applied for AOS concurrently with an amendment from EB2 to EB3. So you didn't file a second I-140, you filed an amendment. Okay. I've recently withdrawn my amendment. Okay, so that amendment was not approved. You have an old EB2 from the same employer and 485J for interfiling. So I'm not sure what the interfiling is for. Are you on the phone? Press star 5 if you are here. Press star 5, please. I guess you are not here. So I'm not sure about what this interfiling is. EB3 I-140 amendment is withdrawn. EB2 I-140 is inactive, active, same company. Pending 485 and 485J. I don't have complete information on your case. So specifically a key piece of information I'm missing is, what is the 485J filed for? You said interfiling. Interfiling from what to what? Because if you amend the case, I'm not sure what your when did you file, who applied for AOS concurrently with an amendment petition? Oh, I see. So your 485 must have been filed with your amendment, which is what you said, which is EB3 amendment. But why did you file a 485J? I guess you wanted to go back to EB2. Okay, got it. Now I'm going to make a guess here. Your lawyer should confirm. But I think the use of the advance parole should not hurt you, because on the date you requested interfiling, your 485 was still valid, right? Because you had not yet withdrawn your I-140, right? So if you made an interfiling request and your 485 was still valid, I think that can just be transferred even though you have used your advance parole. That's my opinion. Have your lawyers double check it. I think that's the way it will go. Okay. *5 if you have a follow-up question. Press *5. Next question is changing employers. As my new H-1B got approved, 797 is dated October 1st. Can I start later than October 1st? Do I need a new stamp if traveling to India? Okay. I work for Company A, non-profit, cap exempt. Got an offer from Company B. They filed cap subject H-1B. It's picked up. Start date is October 1st. Do I need to join the company from October 1st? No, you can delay this. Definitely you can delay this. If I have to join Company B in October, no, that you don't have to. If I can join the Company B after I return from India, in this case I'm still employed by Company A, can I show them Company A's 797 approval notice? Yes, you can. And it's H-1B visa stamp? Yeah. So your H-1B visa stamp is with your old employer, which is cap exempt. Your approval notice is with the new employer. I don't see any problem with you coming back on that visa. So in my view, yes, this should be possible. *5 if you have a follow-up question. All right. Question, there's a follow-up question. Area code 469. Texas. Yeah, Texas, I can hear you. Go ahead, please.
Rajiv sir, how much maximum amount of time I can delay the joining date?
I think you can delay it as much as you want. As long as the company has a job open for you, you have the intention to join them, you can delay it. The maximum I have delayed one of my H-1B entries was over a year. So it's a little bit different situation, but the idea is the same. We had an H-1B approval with a visa stamping option. My guy was working in India for the Indian branch of this multinational. He could not join in United States because his project in India was still going on, and they are part of the same corporate group. The project in USA was getting delayed a little bit, so they decided for him to continue working there. After 1 year, when he tried to enter, we gave him a detailed letter explaining what the circumstances were. They didn't even ask him a single question after they looked at the letter. So I don't think theoretically there is any limit on how long you can stave off. As long as the job exists, continues to exist, they want to hire you and you want to join them. It's a matter of just postponing the joining. Got it?
Okay. Just one more question. There is a rule called 50 days, like someone needs to join within 50 days to run the payroll. Would that apply, or that's okay as long as I want to delay it from my side?
You can talk with their lawyers and figure out the documentation they need to do. The 30-day, 60-day rule is a little different. First of all, I'm not sure how much detail I can go into, but I'll give you a quick overview. When the H-1B is approved, the employer is required to give you a job as soon as you report for duty. If the employee is in the United States, they should start paying them within 60 days of the H-1B approval. If the employee has come from outside, they should start paying them within 30 days of reporting for or entering the United States. But all of this, in my opinion, the way I see the regulations, gets nixed when the employee is making the request and employer is making the accommodation. You are requesting, can you give me 6 more months before I join? And the employer is saying, okay, fine, we'll wait for you. They are not the ones causing the delay, you are. And that changes the equation. Understood?
Okay. Thank you. Thank you, sir.
You're welcome, sir. Okay, let's go on to what will be the effect of October retrospect on my green card processing? Week back, date is current, October dates I'm going to retrogress, I think that's what you are saying. Let me correct that so that we don't have a retrogress. October, the dates are going to retrogress. Well, October, the date already. What would happen to our green card processing dates due to these? See, okay, I think what you're asking me is what is going to be the movement of the. Let me lock the conference first. Sorry.
The conference is now locked.
So what is going to be the movement of the priority dates? So we'll know in the next couple of months how far things are going to move. I think we'll have a much better idea. USCIS has issued a frequently asked questions set on this. One of the things they said that don't be surprised if your green card comes even while the dates have retrogressed, because we might have asked for a visa number if your case was already processed. Not in your case, but in some other people's cases. So let's wait a couple of months and then we can regroup and see where the dates are going. If you have a follow-up question, press *5, please. Okay. There is a follow-up question from area code 973, Newark. New Jersey, I can hear you. Go ahead, please.
Hi, Rajiv. Thank you so much. You have always tried to help in every question I had before. So basically, since there wouldn't be any impact for the other applications like EAD or AP, right?
No.
Because of this?
No, not at all. Right? Not at all. Retrogression does not interfere with your employment authorization or advance parole. Okay.
And one question. Actually, me and my husband live in a different location, and that's how we have even filed our 485. So, what could be the possible questions or possible?
Oh, no. This is,
for him?
Ma'am, these days, enforced bachelorhood because of career considerations is very common. We just finished a green card for a professor. Okay. Couple, husband is in California, wife is in Colorado. That happens all the time.
Okay. All right.
Okay.
That sounds better.
Yeah.
Not to worry. I was worried.
Not to worry.
Yeah.
Okay. Good luck.
Yeah. And once again, thank you so much for
You're welcome, ma'am.
Yeah, thank you.
Bye. Then we come to, let's see. Oh yeah, this is another interesting question. So let's say my I-140 gets approved. Then I leave the United States and I'm gone for 10 years. Can I still keep my priority date? And the answer is yes. And technically, an I-140 once approved is valid forever. And the priority date is valid after January 2017, even if the I-140 is revoked. But if the I-140 is revoked before January 2017, situation may be different. If the I-140 was not revoked, your dates are good forever. If the I-140 was revoked on or after January 17, 2017, your priority dates are good forever. If your I-140 was revoked before January 17, 2017, there is a gray area, some doubt whether you can keep your priority date. Through the sister, it takes 15 years, so I'm not sure how much of an option that is. So just check with your old employer and even ask for you can ask for a Freedom of Information Act request and see if your I-140 was ever revoked. Okay. *5 if you have a follow-up question. All right. So what is the best way to fund an EB-5? Well, EB-5 funding can be your own money. It can be promissory note, for part of the money, promissory note leveraged by your assets, whether here or abroad. It can be borrowed money. The only thing you cannot do is borrow against the property that you are investing in. So let's say you are buying a motel for $2 million. And typically, I think the commercial rate is you put down 20%. So let's say you put $400,000 down. You can't borrow $600,000 against that property and put that as your part of $1 million investment. Okay, or $1 million, 50,000 investment. So you can use any types of funds, including borrowed money, leveraged promissory notes, your personal money. Okay. *5 if you have a follow-up question on this. About DV, I'm very sorry, folks. I don't know anything about DV. I had to look up what kafala means. It's apparently some sort of Middle Eastern thing going on where people are working as migrant labor. I'm not sure how to answer your questions. I don't do DV cases. So I'll have to skip that one. And I think this is the last question, then we'll take new questions. The last question is it advisable for my son to file OPT EAD as a backup if using EB3 green card EAD as a dependent? Is diversity visa an option for Dubai born? Yeah, that much I looked up. Dubai is a part of United Arab Emirates and they are allowed to file for DV lottery. Can I change to a job with a different title on green card EAD? Well, your problem is, I just remember reading your question just a few seconds ago. Let me just double check. My son is using EB3. Oh, you have the CSPA lockup. Okay, got it. Can he apply for diversity visa? Yes. I would like to take a technical consultant sales solution engineer using my green card EAD. Yeah, that's something your lawyers should be able to tell you. I can't really, because the criterion here is same or similar job. So is your sales engineer job same or similar with that of a software developer engineer? That's your lawyers have to look at the two jobs, compare them, and then give you an estimate. So I can't really tell you how this will work out. But I don't think filing OPT EAD is much of an option. I'm not even sure if he would qualify because he already has an EAD. So I would have to actually look into the law on this. You want to try, there is no harm. But I'm not sure the government will give it because if you have a 485 pending, they probably will not consider the student status sustainable. Okay? So who knows? I personally think that the green card EAD is a pretty safe bet. But if you feel like applying for an OPT EAD, I don't see what harm it could do. Okay? For your job, I think that needs to be compared. This is not a question that we can answer hypothetically. Any follow-up question on this? Excuse me. Any follow-up question? Area code 805. Let's see, 805 is California. California, go ahead, please.
Hi, Rajiv. It's my question. So, regarding my son, if he, I just came to know about diversity visa, but, and he's, as I said, is a dependent on my EB3. and he's working currently. But if I apply for a diversity, will that affect any of the
No,
EP3 green card processing? Okay.
not at all.
Okay. Yeah.
Okay.
Yeah. I think that's what I want to clarify. And I think that's it.
Okay. Well, I have just one additional comment for you to note. You know how when you file H1B, H4, L1, L2, you have these visas and you apply for 485. These two can coexist without any problem. I mean, these types of visas with 485. On F1, the government says, well, if you have a 485 pending, you cannot really sustain an F1. But they have never said what will happen if we do. It's not like an automatic cancellation of the student visa because you filed the 485.
Yeah.
So just keep that in the back of your mind. Government has said that they don't think these two 485 and F1 can stay together, but I've never seen a case where they said, well, we revoke the F1. Okay?
Right. I was just exploring that option because I kind of got locked into EP3 and
I saw
couldn't
that.
use EP2.
Yeah, I saw. I understood.
It was current. Yeah.
I understood what you were doing. If he can get his own DV, that would be perfect, right?
Right. Yeah. And his employer is not going to sponsor green card, at least as of now. So
What is your priority date?
just exploring options.
What is your priority date?
It is Feb 2013. Feb 2013.
That's not too bad. Let's see what happens.
Yeah, absolutely.
Good luck to you, sir. Good luck.
Thanks.
All right, bye-bye. Okay, anyone has any question, press *5, please. Anyone has any question, press *5. Oh, very easy. Today we have only 3 questions. Good. Let's go with Arizona first. Arizona, go ahead, please. I can hear you.
Hi, sir. Hi, Rajiv, sir. So, the situation is I am an F1 STEM OPT and my H1B was picked up and approved this year. But I lost my job and they applied for withdrawal. And I haven't received any withdrawal notice yet till now. And my employer's attorney told that they won't share the withdrawal notice. I just have to track online. So, and since the change of status is happening tomorrow, day after tomorrow, is there any way that I can avoid this? I just wanted to know.
Well, first thing what you should do is send an email to the DSO stating that you've lost your job and this is what the attorneys have told you. Please reinstate my service. Make that request and do it in writing.
Yeah.
Okay, number 1.
Yes, sir, I did that. For that, they are requesting the withdrawal.
I know. But I want you to put it in writing why you cannot give them the notice. Okay?
Okay.
Put it in writing, number 1. Number 2, open a case with the USCIS Ombudsman's office. Tell them...
So, which office, sir?
Ombudsman. Om as in Om Shanti Om. O-M. Bud as in flower bud, B-U-D-S, and man,
Okay.
M-A-N, Ombudsman. If you Google USCIS Ombudsman, Ombudsman is a watchdog over USCIS. They are there to correct systemic problems as well as problem individual cases. Okay? Tell them that this is a systemic problem. Also open a service request with the USCIS stating that you don't want to get a change of status and you want confirmation of withdrawal. Okay, do all these 3 things. That way, at least if we tomorrow have to file a lawsuit for you, you have very, very good groundwork already done, because this is a gap in the USCIS regulatory framework through which many students can suffer. You might even end up doing a class action. Okay. So go ahead and do these 3 things.
Yes, sir. Thank you. But if I leave the country tomorrow and come back in 3-4 days, will that help in avoiding the change of status?
No. The problem is, how will you come back? Because your service is already suspended.
Okay.
They won't let you in.
Okay. Yeah. Okay, sir. Thank you. Then I will write an email to my DSO. Second one is ombudsman, the watchdog. I will do that. And third one is a service request to USIHCS to get the withdrawal request to me directly.
Exactly. And please make notes of date, time, and what you did and what you were told.
Okay. Yes, sir. I have everything in written. I will get the dates in that with email.
Good. And so when you go to the USCIS ombudsman, they actually have an option, open a case. Just open a case with them. Okay?
Okay, sir.
Good luck, sir. Good luck.
Sir, just one last thing. I found a new employer. Will they be able to apply for H1B transfer?
See, the problem is, if your H1B is revoked, request is sent before October 1st, government will probably say that you are back in the quota. That your lottery exemption is gone. Okay?
Okay, sir. Thank you. Thank you for this.
Good luck, sir. Good luck. Let's go on to the next one as soon as I can figure out how to do this. 1 second. Got it. Okay, Oklahoma. Oklahoma, I can hear you. Please go ahead.
Hello, Rajiv sir. I have a question that I have lost my job on 17th of this August. And I got a new job recently, which was yesterday. But I have only 2 weeks. After this week, I have only 2 weeks left in that 60 days of time to be on the legal status. So I wanted to confirm, if they do premium processing, do I still have enough time?
Okay, ma'am.
To stay in United States?
Ma'am.
Yeah.
This is how it works.
Yeah.
So LCA takes about 7 days, right? So there's a healthy possibility that they are going to be able to have your H1B transfer in the hands of the USCIS within those 60 days.
Yeah.
And the moment you get a receipt, or even when they physically receive the paperwork, you can start working with the new employer. The race is not to get the H1B approved within 60 days. It is to get it filed within 60 days.
Got it.
Got it?
Sir, in your experience, how much time does it take to get the receipt?
Well, if you do premium processing, the receipt comes via email, so it's within a couple of days.
Couple of days. Okay.
Okay.
Oh, okay, great. So you think I still have the time, right? I still have.
But you don't have time to. You don't have time to take it easy. But you have enough time, if somebody works efficiently, to get your application filed.
The only thing is that I'm asking this question is because I talked to them yesterday. They said they'll offer me. I'm a great candidate, but they were just hesitant about the fact that they still have enough time to file.
Or tell them they have enough time. Tell them to move their behinds. They can file it. Okay.
Okay. Thank you very much.
You're welcome. Good luck.
Thank you very much.
You're welcome. Okay, 2 more questions. This one is from Princeton, New Jersey. Princeton, go ahead, please.
Hello, Rajiv sir. Can you hear me?
Yes, sir, I can hear you.
Hello, Rajiv sir. So my question is regarding B2 tourist visa. So my mom, who's already here for 4 months, her first initial period of these 2 months is going to end. So I just want to ask, can she apply for an extension now? And if so, she can apply for an extension. What is the maximum number of days she can stay back?
Okay.
The reason behind that is my sister, who's also here, she has a 1-year-old kid. So she's planning to stay as much as possible here to take care of the kid. So just want to check that.
Well, even though within our families we routinely take care of each other's children, I would be reluctant to make that as the reason for my tourist extension request, because government could very well say, well, it looks like you're getting paid for childcare. Okay. Not that you can lie, you've got to be truthful in your applications. But remember, if that is the reason, there could be some pushback from the government on that issue. Even more serious is the problem that many times these visa extension requests are not granted. And if they are granted outside the time that is remaining. For example, if you apply today and you ask for 6 months, government could take 8-9 months to process your request. Those 6 months are already gone. That means you'll have to file a second request while the first one is still pending. And if any of those are denied or you leave the USA while these are pending, government is saying you have to apply for a visa again now. Read my article on the Economic Times on tourist visa extensions and the problems the government is creating. Okay?
Yeah, sure.
So if you are willing to take the pain of filing a second application for extension while the first one is still pending, and if you are willing to take the chance of having to go for visa stamping again, I don't see why not. You can go for it. How much time you can spend? Well, you can easily apply for one extension and maybe a second one as well. I don't know what the maximum is. Under certain special circumstances, we've been able to keep people here for years. For example, medical issues or child going to, there are parents that come from India to accompany children who are in middle school or even high school. They want to stay with their children. And for those reasons, we extend tourist visa many times, tourist status. So different circumstances present themselves differently. In your case, those are the two risks that I pointed out to you. One is repeat applications and two is visa revocation. Okay?
Right. Just one more follow-up question. Say, for example, my mom, she's staying here, say, after 2 month extensions, she's staying here for 1.5 years.
Mm-hmm.
So is it a requirement that she goes back to India and stay at least there for 1.5 years again before coming here?
No,
I would. Restrictions on top of that?
There is no rule on that, but I think she should not return for at least 1 year. Okay?
Okay. Yeah, that's clear. Thank you so much.
You're welcome. Good luck. And the last question of the day is from Rhode Island. Rhode Island, I can hear you. Go ahead, please.
Hello, Rajiv, sir. I just have a quick question.
Mm-hmm.
So this is regarding one of the situations that I'm having. I recently got my green card approved. It has been 45 days. However, I just received another offer from another company, and this would be on 2 separate W-2s with my previous employer who sponsored my green card. So I was wondering if it would be any kind of issue if I, take another offer from another company and work on 2 separate W-2s.
You are planning to work simultaneously for 2 employers?
Yes, sir.
So you want to continue working for the green card employer and take a second job?
Yes, sir.
No problem. Go for it.
Okay, sir. And it won't have any,
No, you will work very hard and you will work very hard and you will have more money, but no impact on green card.
Sure. That was all I had. Thank you so much, sir.
You're welcome, sir. Good luck. All right, folks, that was all the questions we had today. Thank you all for joining us. I'll see you again in 2 weeks. Stay safe, everyone. Bye-bye.